Hello and welcome to Topic 8, Lecture 2. And in this lecture, we're going to be learning about the Supreme Court and the main power that the Supreme Court has, which is the power of judicial review. So, what are we going to be learning about in this lecture? Well, first, we're going to learn about the role that the United States Constitution plays in establishing the federal judiciary, including the powers of the Supreme Court. Next, we're going to look at how Supreme Court justices are selected in that process, as well as the sessions of the Supreme Court. We're going to learn about the current court and who sits on it, the Roberts Court, and why it's called the Roberts Court. And then we're going to end with taking a look at the power of judicial review and where that power is derived from, which is from the famous case Marbury versus Madison. So that's what we've got on the docket. Let's go ahead and get started. So the federal judiciary is established by the United States Constitution, Article 3. Article 1 establishes Congress, Article 2 establishes the presidency, and Article 3 establishes the federal judiciary. So in Article 3, it says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So there's two things I want you to take note of here in these words. So for one, that a Supreme Court is established. Keep in mind, under the Articles of Confederation, there was no executive branch. There was also no federal judiciary. And so this establishes the federal judiciary when it says that the judicial power is going to be vested in one Supreme Court. But I also want you to keep in mind, so the Constitution establishes the Supreme Court. But I want you to keep in mind that Congress is the one that establishes those inferior courts that we learned about in the last lecture, the federal trial courts and the federal intermediate appellate courts, the circuit courts, okay? And so Congress, the power there is split between the Constitution and the Constitution giving Congress the power to get involved in the organization of the federal judiciary. So the Supreme Court hears cases that deal with federal law and the Constitution. We learned that in the last lecture. It, as I said in the last lecture, it does have original jurisdiction. In other words, it does act as a trial court. In some cases, it's in the Constitution. I encourage you to look at Article 3, but they rarely exercise their original jurisdiction powers or authority, and they mostly act as an appellate court. The last kind of interesting original jurisdiction that I remember the Supreme Court being involved in was there was a dispute between New Jersey and New York over Ellis Island. And so if there's a dispute between two states, then that trial can take place in the Supreme Court. And so you have the Statue of Liberty on Ellis Island. There's landmass underneath it. New Jersey said that Ellis Island belonged to New Jersey because it was in its borders. And then New York said, no, it's in our jurisdiction. And the Supreme Court had to decide, and they ruled in the favor of New Jersey. But that's a good example of that original jurisdiction. Now, as we know that there's nothing in the Constitution that sets the number of justices that serve in the Supreme Court. The size, the number of justices is not set in the Constitution. It's Congress that establishes how many justices are going to serve on the Supreme Court of the United States. It's varied over time, okay? And so we've seen the court, I think, go as low as 5, back up to 6. I think the largest it's ever been is 10. However, since 1869, the number of Supreme Court justices has been set at 9. But as you know, because there's been a lot of anger, particularly among Democrats and progressives, about the recent decisions of the Supreme Court that go against longstanding precedent, there has been some talk about increasing the size of the courts. They could do that. It would be completely constitutional, but you would need the political power to do that. In other words, you need to have enough people in Congress to get that done. We know that in the Constitution, it says that there will be in Article 1, not in Article 1, but it says that there will be a Chief Justice, okay? So we know that there's going to be a Chief Justice, and since there's a chief, then we assume there's going to be associate justices. And that's what's been established by the Judiciary Acts over the course of our country's history. As I mentioned above, Congress establishes the inferior courts. And so they establish the number of district courts, and they also establish the number of U.S. courts of appeal. Keep that in mind because it plays a big role in the power grab of John Adams and Marbury versus Madison. But the U.S. District Court and Court of Appeals been set at their number for quite some time. So as we know, the framers of the Constitution wanted to make sure that they gave specific powers to the President of the United States, but they didn't want that power to be abused. And so they put certain checks and balances on the president. And so we learned in the last topic that one of the executive powers of the President of the United States is the ability to select the judges that they would like to serve, not just on the Supreme Court, but on the lower federal courts as well, appellate courts and justices on the trial courts of the federal system. So let's talk a little bit about the selection and the services of justice, and also a little bit about the Supreme Court term. This is the latest justice to be confirmed by the Senate. That this is Justice Ketanji Brown Jackson, that she was nominated by President Biden and confirmed by the Senate. And so she replaced Stephen Breyer on the Supreme Court. So she's the newest member. And so she was obviously nominated by the president and confirmed by the Senate. You used to need to have a 60 supermajority to confirm justices on both the Supreme Court and the lower federal courts, but that is no longer the case. Now you just need a 50% plus one majority. That, as we know, service on the Supreme Court, it's a lifetime appointment. And so you serve until you retire or you serve until you die. It's a lifetime appointment. And one of the trends that we're seeing recently is for presidents to pick really young justices. Donald Trump did that, but so did Joe Biden, because Ketanji Brown Jackson is quite young. And so that they basically, if they are appointed in their early 50s, I mean, they could, in theory, be on the court for 30 years. And so that's something that's relatively new. It is a lifetime appointment, but like all federal officers, that they can be impeached. There haven't been a lot of impeachments over the history of the Supreme Court, and it hasn't happened in modern history, but it can take place. There are no constitutional qualifications to be a member of the Supreme Court. I'm sure that the framers felt like those kinds of qualifications were not necessary because they trusted both the president and the Senate to make sure that those who were selected to serve on the Supreme Court had impeccable qualifications. However, there are some sort of, maybe not by law qualifications, but there are some, sort of trends that we see in terms of the qualifications that people have who serve on the Supreme Court. And so for the most part, not all, but for the most part, people have served on the Supreme Court. They are federal justices. They've served on the appellate court, the circuit courts, because that's like a stepping stone up from the district courts. That sometimes they will serve as the Solicitor General. That Elena Kagan was the Solicitor General under Obama, which is the top lawyer for the president, or not for the president, but it's the person who represents, it's the lawyer who represents the United States at the Supreme Court, if the United States is one of the parties, okay? And so we do see some themes of that, and also most of them go to Ivy League schools, Harvard, Yale, or Columbia. The Supreme Court has a very specific session that's set in their rules, that it starts on the first Monday of October. And so we're a couple of weeks into the current session. the 23-24 session of the Supreme Court. And then the court session ends in June, and then the justices take a break during the summer. Some travel, and others just work on other things, books. But yeah, they do. It ends in June. And another thing to keep in mind is it's usually at the end of June. Recently, that the blockbuster cases are decided. Okay, and so for example, in 2022. There was obviously the abortion case that overruled Roe, that there was the Bruin case that extended the right to the individual right to bear arms. There was an EPA case, the administrative state case. So there are lots of blockbusters, and for whatever reason, they wait to the very end to announce those, maybe so they can hightail it out of the out of Washington, D.C. There's some cool books you could read. I teach civil liberties, and we read a book called The Most Dangerous Branch, which really gives you an inside look at some of the workings within the Supreme Court. Also, that there is a SCOTUS blog. That is something that is it's a website that's dedicated to the Supreme Court. And at the end of the term, it's always fun to get on and wait for the decisions to be announced because you're with a bunch of other Supreme Court nerds who are waiting for certain cases to be decided. And so those are just two recommendations for you if you want to get more deeply into the workings of the Supreme Court. So this is the picture of the Roberts Court. And it is called the Roberts Court because John Roberts is the Chief Justice of the Supreme Court. Okay. And so there's one Chief Justice and there are 8 associate justices. Okay. And so when a new Chief Justice is confirmed, that the name of the court changes. So before the Roberts Court, it was the Rehnquist Court. And before that, it was the Berger Court. Before that, it was the Warren Court. Okay. And so the courts are named by the Chief Justices. Okay. The Roberts Court has been going on for quite some time. John Roberts was nominated and he was confirmed by George W. Bush. And so, we're about 20 years plus into the Roberts Court. Now, every time there's a new person that joins the court, the Supreme Court takes a picture, like a class photo. And they recently had a series of photographs in the Times. And if I can find the link, I'll put it, below this lecture so you can take a look at it. But that the photography, the class photo of the Supreme Court has been going on since the middle part of the 19th century. And it's just amazing to look at the photographs over time. And so here we have it. And they're not just sitting there in a random order. There's a specific order that they're sitting in. So the Chief Justice has the most power. He's the most senior justice on the court. And then from there, it goes from the Chief Justice to those who have served on the court the longest. And so Clarence Thomas, Sam Alito, Sotomayor, Elena Kagan, and then we have Neil Gorsuch, Kavanaugh, Amy Coney Barrett, and Ketanji Brown Jackson. Okay, and so these are the folks who make up the Supreme Court, with the newest member here, the Chief Justice here, and the person who served on the court the longest, Clarence Thomas, here. Okay, Supreme Court. And let's just, every time we do something, this finally brings us to the last part of the lecture, which is the power that the Supreme Court has. And the power that the Supreme Court has is, it's one of its most important powers, is what's known as the power of judicial review. And basically what judicial review is that the Supreme Court can invalidate federal law, the actions of Congress, the actions of the executive branch, like an executive order, or the actions of states or local governments, if these laws are deemed to be unconstitutional. So there it is. It's the supremacy clause, right? That if any of those laws violate the Constitution, and the Supreme Court says, indeed, it does violate the Constitution, not only are they just saying that the Constitution is violated, but those laws are then nullified, okay? This power is not found in the Constitution, but it is derived from the one of the probably the most important cases of the Supreme Court, and one of the earliest decisions it made in 1803, which is the case Marbury versus Madison. Now, you might be sitting there thinking, okay, Hankinson, I'm hearing all this, but what the F is this? Why do you have that duck that has like a brace on its leg? What is that doing there? And what relevance does that have for judicial review? Well, this case, Marbury versus Madison, comes out of the election of 1800. It is the first election where there are two parties that are running against each other for the first time. John Adams is a Federalist, and there weren't political parties at the founding of the framing of the Constitution. We didn't have political parties. We called people the Federalists because they supported the Constitution. But Thomas Jefferson, if you've seen Hamilton, you see this play itself out, started getting sick of the Federalists, John Adams, and Alexander Hamilton and George Washington. And so him and James Madison created a new party, and it was called the Democratic Republicans. And so John Adams, and so in the election of 1800, it was an election between two different parties. That it was the Federalists as represented by John Adams, and it was Thomas Jefferson represented by the Democratic Republicans. And the Democratic Republicans won and the Federalists lost. And it was a huge deal because it was a transfer to a new party, and the Federalists hated the Democratic Republicans, and likewise. And I've got a campaign ad for you to watch in our for fun that shows the campaign ads, between John Adams and Thomas Jefferson. What happened is that John Adams, it was a lame duck presidency. And, in 1800, in 1801, when he was leaving office, he didn't leave office in January, but at that time it was in March. And so John Adams said, you know what? We may be getting kicked out, but we're going to leave our mark on this country. The Federalists are. And what we are going to do is we're going to create a whole bunch of new federal courts, because the presidency and the legislature was all in the hands of the Federalists. And they're like, we're going to totally pack this court. We're going to create new courts, and we're going to pack them all up with Federalist judges. And so that's why that lame duck is there, because John Adams and the Federalists were a bunch of lame ducks, and they're like, we're going to do wreak as much Federalist havoc as we can before those damn Democratic Republicans take office under Jefferson and Madison. So who are the main players in Marbury versus Madison? And basically, what is this case about, and what does it have to do with judicial review? Well, as I mentioned, the main players here are John Adams. He's the former president until 1801. So he's the president until 1801, okay? And he is a Federalist. But by 1803, he is a former president. He loses in the election of 1800 to Thomas Jefferson, who in 1803 is the current president, and as we know, is a member of the Democratic Republican Party. And his Secretary of State, and that is why it's called Marbury versus Madison, is James Madison, okay? So as you recall, John Adams and the Federalists, they packed a bunch of courts. They created a whole bunch of new courts, and then they filled them with Federalist judges. And this dude here, William Marbury, okay, as in Marbury versus Madison, he is one of the justices. And so there is a court justice. He was appointed as a federal justice of the peace. It was a new court that was created, and he basically, was tapped. He was nominated by John Adams. In fact, he was to serve as that judge. But to actually become a federal judge, that you just don't need to be nominated and confirmed, but you actually have to receive this thing called a commission. That's like a piece of paper that says, indeed, you are a federal judge. Okay. So William Marbury, he had every right to this becoming this federal judge. However, so why didn't he become a federal judge? Well, he didn't become a federal judge because on the day that Thomas Jefferson took office and moved into the White House, he went into his office, and on his office desk, the office desk that was previously used by John Adams, there was a pile of court commissions. Okay, and he looked through them, and these were all commissions that were going out to these federal judges. And and William Marbury's commission was one of those. So it was sitting on Thomas Jefferson's desk. And Thomas Jefferson was livid that the Federalists had packed the courts with all their damn judges. Okay. Not only did they pack the courts with all their damn judges, but the new Supreme Court Justice, John Marshall, he was a Federalist as well. Okay. So what Thomas Jefferson did is he said, you know what? I am not going to deliver those those federal judge commissions. Those 7 people who had those commissions, they're shit out of luck. Okay. And William Marbury was one of those people that never received their commission. And understandably so, he was mad as hell. Now, Thomas Jefferson did this because he was like, well, what are they going to do? Like, roll in the troops and force me to deliver these commissions? Plus, the Democratic Republicans were in town now, and nobody would abide by that. So Thomas Jefferson felt like he didn't have to do it, even though he should have done it. He didn't feel like he had to do it because that there wasn't the political power to follow through in making him do it. Well, William Marbury, a judge, very learned, that William Marbury wanted to get his commission. And so what William Marbury did is that he looked at federal law. And within federal law, as it says there, within the Judiciary Act of 1789, federal law said that if a federal officer fails to do their job, like Thomas Jefferson, by not delivering those federal judge commissions, that the Supreme Court of the United States can force the judge, can make the Supreme Court issue what's known as a writ of mandamus. And basically what a writ of mandamus is that, and it came out of the Judiciary Act of 1789. And basically what that law said was if Jefferson or any other federal officer isn't doing their job, then the Supreme Court has the authority to issue a writ of mandamus. And what a writ of mandamus does is that the court is forcing Thomas Jefferson to deliver those commissions. And so William Marbury was super smart, and he asked the Supreme Court to hear his case, saying that the court had the authority to force Jefferson to give him his commission. Well, John Marshall, the new Supreme Court Justice, was like, shit, what am I going to do, right? That if I issue a writ of mandamus, Jefferson's not going to follow it, and it's going to make the federal court seem weak as F. But he really felt like William Marbury was wrong. And so how did John Marshall solve this? What he did is that he established judicial review. What he said is that William Marbury had every right to his commission. And in fact, William Marbury he was harmed, and that harm should get some redress, that it could get some remedy. But he said, trying to get that remedy at the Supreme Court, you're not going to find it here. Why? Because that Judiciary Act 1789 provision that gives power to the Supreme Court to issue writs of mandamus is unconstitutional. It basically expands the power and authority of the Supreme Court, and that's not within the authority of Congress to do. So basically said that provision that gives the Supreme Court that power to issue writ of mandamus is unconstitutional. And as such, that provision of the law is null and void. And too bad for William Marbury, because he never got that commission to serve on that. But that is the moment where the power of judicial review is born. Okay, now that we know what judicial review is, let's see how judicial review is used in action. And so one of the ways that judicial review is exercised by the court is when it comes to acts of Congress. If somebody thinks a federal law, an act of Congress is unconstitutional, they will ask the court to review that law. And if the court agrees to hear it, then they will review that law. A good example of that is the case Citizens United versus the Federal Election Commission. Citizens United was a independent political group that created this movie called Hillary, the movie. You'll notice the date there of the case, 2010, and you probably don't recall, but Hillary Clinton ran for president in the primary against Barack Obama in the 2008 cycle, and obviously she didn't win. But Citizens United wanted to broadcast this movie during the campaign in order to, it was not a favorable movie towards Hillary Clinton. There was a big criticism of Hillary Clinton. Well, because of so there was a federal law passed. It was called the Bipartisan Campaign Reform Act. And in that act, one of the provisions placed restrictions on corporations funding political communications, like the movie Hillary, the movie, right? And Citizens United was pissed. They said that was their freedom of speech, and that law, the Bipartisan Campaign Reform Act, violated their First Amendment rights. And the Supreme Court agreed with that. They basically said that placing those restrictions on corporate spending on political speech is unconstitutional. And that provision of the Bipartisan Campaign Reform Act was nullified. Judicial review in action. The Supreme Court can also exercise judicial review over presidential power. And so a good case that illustrates that is the case Hamdi v. Rumsfeld. In that case, notice the date, 2004. This was after 9/11, which took place in 2001. And this is a case about a Taliban fighter who was captured in Afghanistan by the United States government. And his last name was Hamdi. Now, the Bush administration had created this category called enemy combatant during the so-called war on terror that started after 9/11. And it basically was the Bush administration's way of getting around the international laws regarding the treatment of prisoners of war. So by being called an enemy combatant, you weren't a prisoner of war, and you were not afforded certain international protections. And that was the case with Hamdi. What happened, though, is that Hamdi was brought back to the United States, but it turns out, as an enemy combatant, but it turns out that he was actually a U.S. citizen. So he's being held as an enemy combatant with no political rights or rights of the criminally accused. That he wasn't told what he was being charged with. He, was not given an attorney. And Hamdi basically said, as a U.S. citizen, he had those rights, and those rights should be afforded to him, even though he was, fighting for the Taliban in Afghanistan. And the Supreme Court agreed. They basically said that the Bush administration, the way that they were exercising power, was unconstitutional, and they needed to stop exercising their presidential power in that manner. And then obviously that the Supreme Court can exercise judicial review over state laws. Because of the supremacy clause, federal law is supreme. And so the decisions of the court as to the constitutionality of things applies to the state law as well. And Texas versus Johnson is a good example of this. In Texas versus Johnson, this is a case having to do with freedom of speech. Texas passed a law saying that it was a criminal offense to burn a flag, to deface a flag, because the flag is this important symbol that should be respected. Well, Johnson didn't agree with that. He was at a protest, and he burnt the American flag in protest against the United States, and he was arrested and charged with violating the Texas law. That came to the Supreme Court, and the Supreme Court, looking at Texas law, they said that it actually was unconstitutional. It did violate Johnson's freedom of speech, and so therefore that Texas law was found to be null and void due to the judicial review. I want to end this lecture by just giving you some critical thinking questions to think about as we sort of move forward to the final. You might be asked to think critically about judicial review. And so, one question is, should an unelected judicial body like the Supreme Court have that power to overturn the actions of an elected legislative body, right? And so, like in an imaginary world, you could have 435 members of the House and 100 senators all agree that they want this law and the president signs it into action. But you could have 5 out of 9 justices declare that law unconstitutional. Is that something that one should be concerned about, or is that a power that's really necessary for the rule of law to, be vibrant and meaningful within a democratic society? Should the courts defer to legislatures, let them resolve disputes with the law, rather than people keep coming to the courts asking, "Oh, our state legislature passed this law, do something about it, overturn it." Well, should the Supreme Court pay more deference to the legislative branches? Are there any checks on the Supreme Court power of judicial review? Are there adequate checks to prevent the Supreme Court from abusing its power? And then what are the benefits of the Supreme Court exercising judicial review, and what are some of the drawbacks? All right, that's it for me. I'm sorry this was a little bit longer than usual, but, well, Marbury versus Madison. All right, thanks for listening. Appreciate it, and I'll talk to you again soon.